The shark told me.
You know, you don't ever say that to a woman.
We had a 3-hour meeting. And by the end of that meeting, I just knew she was Lily. We had a
federal judge just drew a hard line. This courtroom isn't a stage and filings aren't props. Overnight, a celebrity lawsuit that had been drifting into the gossip current snapped back to the rules. One oversized deposition pulled from public view. A stack of documents sprinkled with personal phone numbers and emails. Send them back, black them out, and try again. Why does that matter? Because when private data slips into a public docket, it doesn't just make headlines, it spreads.
The motions to dismiss are granted.
And when legal paperwork starts looking like a press kit, the story stops being evidence and starts being narrative. That's where power shifts from the judge's bench to the timeline. So here's the real question. Who benefits when a filing burns hotter than a headline? The side that wants the spotlight or the side that wants silence? The answer is buried in what the court just signaled. Keep the case in the case, or it won't stay public for long.
Judge Lehman just gave you and me, the public, access to call in and listen to the hearing on July 15th.
But that wasn't the whole story. Strip away the noise and you get a simple clash. Reputation versus narrative control. One side says coordinated whispers turned into published facts, then into lost opportunities. The other side says that's fiction, and that the real harm is the accusation itself, amplified by headlines and hashtags. Both stories can't be true, and that's why they brought it to federal court. From day one, the case split in two.
The judge made some orders. Not much to it, but Judge Lyman says, tag employees.
The public version, everyone thinks they know, and the private version built inside discovery. The public version is loud, clips, posts, think pieces. The private version is granular. Email threads, draft pitches, invoices, call logs, PR calendars. That's where lawyers hunt for patterns. Who texted whom, when, about what, and whether those whats line up with public moments that moved the needle. If there's a campaign, it should leave fingerprints.
Blake Lively was not deposed yesterday. Judge Lehman decided to give Blake everything that she wanted, basically everything her team,
If there isn't, the absence of those prints matters just as much. What makes this fight different is how quickly filings became content. Each side argues the law, then watches the internet argue the optics. A declaration lands, a transcript surfaces, a motion quotes a spicy line. And suddenly fans and commentators are acting like junior paralegals. That feedback loop pressures the court to keep the rails on. Let the record be evidence, not entertainment. Let redactions protect people, not narratives.
Judge Lyman has entered the chat and he told y'all to shut the fuck up. He told y'all. Listen.
Let the jury, not the timeline, decide what sticks. Inside that framework, the legal questions are sharp and boring in the best way. Did specific statements cross from opinion into defamation? Were private details used in ways that broke rules or contracts? Do PR moves count as coordination or just publicity? Those answers don't come from vibes. They come from receipts. And receipts live in the documents nobody sees until the judge says they can.
Yeah!
So, where does that leave us? With a case that keeps smacking into culture. The filings try to be precise, the discourse tries to be viral. The judge's job is to stop one from poisoning the other. That's why the tone around this lawsuit feels different lately. The court is tightening the tap, insisting on cleaner records, sharper redactions, and less theater. Not to silence the public, but to keep the trial from being decided by a chorus that doesn't have to swear an oath. And that tension between what's admissible and what's irresistible,
Ryan Reynolds is allegedly clearly paying for the legal bills in Blake Lively's lawsuit against Justin Baldoni.
Is exactly what set up the next flashpoint. A document dump that read like a headline generator and a judicial response that said, in plain terms, enough. It landed with a thud, a sprawling deposition transcript, hundreds of pages long, uploaded for the world to skim. Not summarized, not excerpted. The whole thing, raw, electric, and ready to be clipped into moments. The problem wasn't just length. Depositions aren't closing arguments, they're messy.
Blake Lively allegedly hasn't paid for any of her legal bills with her lawsuit against Justin Baldoni, and Ryan Reynolds
Half answers, objections, context that arrives 5 questions later. In a courtroom, that raw material gets filtered. On the internet, it doesn't. The judge saw the risk immediately. Turn this into a spectacle and the evidence becomes entertainment. Jurors, future or potential, could be primed by sound bites before a single exhibit is admitted. That's not transparency. That's trial by timeline. So the court yanked it back.
Hell yes. Judge Lyman's making some calls early this morning, and Lauren at Court of Random Opinion.
Not because the case vanished, but because the process matters. A record should build toward truth, not toward trending topics. The order was a signal. Stop feeding the hype machine with unprocessed testimony. Both sides read that signal differently. One camp says it's about fairness, keep the noise down so the facts can breathe. The other says sunlight is a disinfectant. If the testimony helps us, why hide it? The court's answer, because procedure isn't a vibe, it's a guardrail. There's another layer most viewers miss.
Brett Douglas McDowell has filed a formal motion to recuse Judge Lindman from the Blake Lively case. Let's break down everything in the...
Depositions are designed for lawyers, not audiences. A clipped sentence can look like a confession or a dagger when the next 3 pages would dull the edge. Pulling the document was less about secrecy and more about preventing distortion. And yes, there was timing. The filing didn't appear in a vacuum. It dropped into a media environment thirsty for a narrative twist. Memes, threads, gotchas. Every paragraph was a match. The judge poured water on the pile. Did the move silence the story?
So Judge Lyman, the judge in this case, might have missed the spot. Is Judge Lyman reading these motions and writing these orders?
Not really, it reframed it. If you've got proof, bring it through motions, hearings, trial. If you've got headlines, keep them off the docket. That's the line the court drew. Content versus evidence. What's left is strategy. Without a viral transcript to surf on, each side has to argue the law, not the heat. That means tighter briefs, cleaner exhibits, fewer theatrics. Boring, maybe. Effective, definitely. And just when the temperature seemed to dip, a second flashpoint sparked.
So apparently Judge Lehman, who is the judge for the Blake Lively versus Justin Baldoni case, has a brother, Doug Lehman.
This time about something even less glamorous than testimony. Phone numbers, email addresses, and what happens when private data slips into a public file. But that wasn't the whole story. It wasn't a bombshell quote that set off the next alarm. It was something smaller and riskier. Phone numbers, email addresses, private details that slipped into public filings and sat there long enough to be copied, clipped, and cached.
Okay, I might not be Team Justin, but I'm firmly not Team Blake Lively. Yeah. I'm anti-Lively.
Okay, yeah.
Courts hate that. Not because they're hiding the ball, but because once personal data escapes, it doesn't come back. Screenshots outlive corrections. A redaction made tomorrow can't erase what was downloaded today. So the judge did what judges do when the record turns dangerous. Pulled the filings, ordered clean versions back on the docket, and drew a bright, simple rule: black out personal contact info before it ever hits the public file. No permission needed, no excuses later. That sounds procedural. It isn't.
Looks like Judge Lehman may be in trouble. Today, a legal memorandum that was filed by Brett Douglas McDowell is asking the court...
In a case where every upload gets spun into content, preventing docs fuel is the difference between legal strategy and collateral damage. Keep the evidence. Cut the exposure. It also undercuts a favorite internet sport, connecting mystery numbers to real people and building theories from a string of digits. With mandated redactions, the narrative has to come from arguments and exhibits, not breadcrumbs, that can lead to someone's doorstep. And yes, there's a message tucked inside the order.
Looks like Judge Lehman may be in trouble. Today, a legal memorandum that was filed by Brett Douglas McDowell is asking the court.
If you want the public to see your evidence, show the evidence, not bystanders' data, not private routes into someone's life. That's not transparency. That's volatility. The immediate impact is tactical. Future filings get slower, tighter, safer. Teams have to scrub before they share. Editors, not just litigators, become crucial. One sloppy exhibit can set off another round of sealing, refiling, and backlash. Did that cool the rhetoric? Briefly.
Is Ryan Reynolds really trying to steal Taylor Swift's thunder? Okay, guys, we will deal with my views as someone.
But it also sharpened the fight. If you can't score points with spectacle or accidental leaks, you need substance that survives the red pen and the rules. And just as the paperwork got cleaner, the conversation moved to a louder arena where creators, pundits, and third parties tried to narrate the case from the outside, which is where the next flare-up began. The filings didn't just land in court, they landed in feeds. Within hours, creators were slicing screenshots into reels, threads, and hot takes.
I'm Team Blake Lively. I'm switching sides because I've had enough. Can you believe that Blake Lively says justice?
Some saw a crusade for truth, others saw a playbook for pressure. Either way, the docket turned into content. Fast. That's where third parties stepped in. Commentators with big audiences framed the case as a morality tale, then treated every order like a plot twist. One high-profile blogger even said he reached out to the judge after claiming photos of his family appeared in the public file. His words, his framing, amplified in real time. Supporters called it accountability.
All right, you guys, we've got a new docket. Woo, woo, woo. If you are here and you have...
Critics called it performative outrage. The court called it nothing, at least not in headlines. Courts speak through orders, the internet speaks through algorithms. That gap is the problem. On social, a blurred number becomes a breadcrumb. A name in a footnote becomes a villain. A sealing motion becomes, what are they hiding? The risk isn't just noise, it's fallout. Once a private detail escapes, you can't rewind the timeline. You can only argue about intent, which is why the judge's redaction rule hits harder than it looks.
This is some more information in regards to the motions to dismiss that have been granted to Lively's side. I consulted with my attorneys.
It doesn't just protect people, it starves the outrage machine of easy targets. No contact info to chase, no bank digits to connect. If you want to win the narrative now, you need arguments, actual ones that survive the record, not just the repost. Meanwhile, both sides know how this plays outside the courthouse. One story paints vigilance against harassment, the other paints a strategy of selective transparency. Each camp claims fairness, claims facts, claims the high ground. The audience picks a team long before a jury is even picked.
Blake, this is why people think that you ain't This is why.
So here's where we tighten the lens. What's verified and what's just loud? What the court has actually ordered, and what the internet merely decided was true. That line matters, because it's the only way to tell who's building a case and who's building a storyline. Think of the case as two parallel tracks. One is slow and stamped. Orders, motions, sworn statements, schedules. The other is fast and sticky. Threads, clips, stitched commentary.
What happens if the judge is dismissed? And welcome to Flow Some Talk. I'm Tashti Flo, and here on my channel, I talk about my...
The outcome rides the first track. The public mood rides the second. Verified means you can point to a document that carries weight inside the case. A judge's order with a date and signature, a motion on the docket filed by counsel of record. an exhibit authenticated by someone who could be cross-examined. Even when those materials are messy or incomplete, they are the raw ingredients a jury can legally taste. If the court says a deposition shouldn't be public, that directive is real whether it fits the narrative or not.
Not only did we figure out how Taylor bought her music, but we figured out her reaction when she found out she officially owned it all. Right off the bat.
If the court tells parties to scrub contact details before filing, that's procedure, not PR. Verified is boring for a reason. It's meant to survive heat. Loud is everything optimized for reaction. A screenshot without context, a sentence clipped from 100 pages, a creator's theory that feels right because it matches what you already believed. Loud thrives on timing, dropping a spicy excerpt the hour a new order lands.
Hello, everyone. So I have some brand new information about the organizations that you can reach out to express your concerns about.
And on gaps, inviting you to fill missing pages with certainty. It travels further than verified because it costs less to share than it does to prove. The trick is that verified and loud often touch the same moment. A party files a declaration. Verified. Someone isolates one line and declares victory. Loud. A hearing gets scheduled. Verified. Commenters announce what the judge really meant. Loud. The overlap is why people get lost. They think they're reading evidence when they're reading interpretation about evidence.
Taylor let everyone know exactly how she feels about Blake, and she has a message for Blake too.
It's not my business. I have actual business.
Here's a simple way to separate them without losing the plot. When you hear a claim, ask what form it takes. If it has a docket number, a filing date, and a caption, you're probably on the verified track. If it relies on sources say, a cropped image, or a narrator telling you what a judge basically did, you're on the loud track. If both are present, treat the loud as color and the verified as spine. The spine is what stands when the color fades. Intent is where speculation explodes.
Not even 24 hours later, and Brett Douglas McDowell has filed an addendum to the motion.
Why did a team file a transcript that day? Why quote that text and not the next page? Those are fair questions, but they aren't answers. Courts don't rule on vibes. They rule on whether a statement is admissible, whether a privilege holds, whether a redaction is proper. If you can't tie a claim about intent to a procedural win, sanctions, exclusion, a ruling, you're still in the realm of argument. There's also a danger in assuming absence equals concealment. A sealed exhibit doesn't mean a smoking gun is hiding.
Here is how I think the trial is going to go next March. Every time
it can just mean personal data, trade secrets, or third-party materials that the law keeps out of public view. Conversely, a public exhibit isn't truth by itself. It's a piece that gains meaning only when the court lets it in and the other side has a chance to test it. Apply that filter to this case and the picture sharpens. Verified, the court is narrowing what belongs in public view and how. Verified, some filings that fed online discourse won't play the same way going forward.
I think she's fishing and she's panicking. I don't think they have what they need to prove her claims, and they are panicking.
Loud, sweeping claims about weaponized fans, leaked strategies, or total vindication, built from a few lines and a lot of certainty. The internet rewards bold conclusions. Trials reward careful ones. For viewers, the smartest posture is curiosity without commitment. Track the calendar, not just the chatter. Look for the next motion, the next hearing date, the next order that tightens or loosens the rules.
Yes, quick recap. After the hearing about the subpoena to the liner
Those are the moves that change the board. Everything else, no matter how viral, only matters if it survives contact with the record. Now the case moves from noise to needlework. First come the housekeeping fixes the court demanded. Refiling exhibits with contact details blacked out and pruning any attachments that read more like press than proof. That alone slows the pace. Every document has to survive 2 tests: legal relevance and basic privacy hygiene.
Watch me debunk the smear campaign in less than 5 minutes. Are you ready, Blake? Take notes. Let's go down memory lane and take it back to where it all...
Before it touches the public docket again. After that, expect targeted motion practice. If one side thinks the other crossed a line with filings or disclosures, you'll see motions to strike, sanctions requests, or, more likely, firm reminders from the judge about how evidence should enter the record. The bigger motions, summary judgment or partial summary judgment, arrive only after the paper trail is built. Those are the filings where lawyers try to win slices of the case before a jury ever hears it.
All right, internet, this is your moment. Everybody that has been in my comment section making these comments, this is your shining moment.
Discovery keeps grinding in the background. Privilege logs get tightened, subpoenas argued, deposition excerpts negotiated. If either camp wants to keep materials sealed, they'll need concrete reasons and narrowly tailored redactions. The court has already signaled that spectacle isn't a reason. Specificity is. Scheduling matters more than headlines from here. The judge sets briefing calendars, hearing dates, and pretrial deadlines. Miss one and your leverage shrinks. Hit them and you control tempo.
Well, ladies and gentlemen, it seems that evil has once again prevailed because a federal judge has just officially thrown...
That's why the public might feel a lull even as the real work intensifies. Serious cases get quieter when they get closer to decisions that actually bite. If the case survives the motion gauntlet, pre-trial orders lock in the battlefield. Which exhibits come in, which witnesses can testify, which topics stay out. That's where strategy turns practical. A single exclusion, one text thread, one email chain can swing the narrative more than a month of trending discourse.
I love this. Hello, my fam. It is Perez, the queen.
All of this points to a simple truth. The next meaningful twists will look like PDFs, not plot twists. They'll arrive as rulings with dates and signatures, and they'll matter because they change what a jury is allowed to see. The timeline will keep guessing, the docket will decide. This isn't just law, it's life online. Privacy feels fragile, and fame magnifies every crack. When a filing leaks contact details or a transcript turns into content, the risk doesn't stay abstract.
She got her way. Not a surprise here. Hello, my fam. It is Perez, the queen.
It lands in inboxes, DMS, and real neighborhoods. People sense that even if they've never seen a courtroom. That's why this case plays like a referendum on boundaries. There's also power. Not the red carpet kind, the narrative kind. Whoever frames the first 30 seconds often frames the next 30 days. A single line from a deposition can crown a hero or build a villain. The court is trying to slow that down. Viewers are used to speed. Then there's PR.
Promoted, it ends with us. And then the stark difference to how she's promoting herself and her brands now.
Legal teams fight over what's admissible. Publicists fight over what's memorable. Fans become amplifiers. Critics become archivists. Everyone claims truth, but the algorithm rewards the most dramatic version of it. That tension turns filings into fuel and commentary into currency. Audiences care because they recognize the trade-offs. Transparency feels righteous until it exposes the wrong person. Redaction feels sneaky until it protects someone who never signed up for the spotlight.
Following the court's order, Mr. Friedman began violating it and has continued to expose the public and the jury pool to his...
Most people don't want secrecy. They want safety. They want receipts without collateral damage. And they care because the stakes are bigger than two names. If courts can't keep cases from becoming content wars, future trials will be argued in public before they're argued in court. That's not entertainment, that's erosion. So the pull is real. Watch the show or watch the standard. The show offers instant answers. The standard offers durable ones.
And the judge says, absolutely not, denied. says the court will not entertain a motion to quash unless
Which choice wins determines who holds the mic when reputations are on the line, and how each side plays the next move. Strip the case to incentives and you see the moves. One side chases daylight, more context, more quotes, more visibility, betting that public momentum hardens into courtroom gravity. The other side plays keep away, tight filings, narrow claims, fewer sparks, betting that credibility grows in quiet. Both are rational. Both are risky.
I was actually trying to get her to do another film of mine, and they told me that she was entirely unavailable, that it's not worth it.
Visibility is a double-edged blade. If the public buys your version early, every new document looks like confirmation. If it backfires, you're suddenly explaining screenshots instead of arguing law. Minimalism has its own trap. Say, too little for too long and the vacuum fills itself. The internet writes your story without you. Judges don't referee brand wars, but their orders rewrite the board. Yank a viral transcript and you blunt the fast game. Mandate redactions and you starve the breadcrumb hunters.
Michael Gottlieb contacted an attorney who represents Taylor and demanded that Taylor release a statement of support for Blake.
What's left is the slow game. Briefs, evidentiary rulings, witness lists. That favors whichever side can survive without applause. Reputation isn't decided once, it's leased. Each filing renews or reduces the term. A clean, focused record signals steadiness. A flashy, messy one signals heat. Jurors feel that even if they don't know why. They weigh coherence as much as content. If your story can't travel from feed to jury instructions without losing shape,
It doesn't say if they're fighting it, doesn't say if they're not, it just says, hey, FYI. So Blake doesn't have our emails. It was YouTube that...
it isn't a case theory. It's a moment. The smartest players plan for silence. They assume a lull, then design what survives it. A timeline that doesn't wobble, exhibits that explain themselves, witnesses who don't need rescuing. Win those, and you don't need a trend to carry you. Lose them, and no headline can fix it. So the board is set. Sunlight versus scarcity, noise versus nuance, speed versus structure. The winner won't be the side that shouted the loudest. It'll be the side whose version of events still makes sense.
Girl, I'm there with you. I'd bet on your pony any day. You can answer if you can answer that question without revealing attorney.
After the judge's pen has crossed out everything that doesn't belong. Boil it down and you get two bright lines. First, the court isn't letting this turn into a performance. A mammoth transcript came down and the message was clear. Evidence belongs in court, not in a viral reel. Second, privacy isn't a suggestion. If contact info slips into the public file, it gets blacked out and refiled, because once it's out, you can't pull it back. Everything else is posture.
They have in there, so those are the only legs that they're able to stand on is because they still have that claim left in the case.
One side leans on visibility, the other leans on restraint. Both are betting on how attention shapes belief. But the rulings tell you what actually matters next. Cleaner filings, tighter arguments, fewer theatrics. The big swings won't arrive as leaks or clips. They'll arrive as orders that decide what a jury can hear. So, read this case with two buckets. In one, the verified stamped orders, scheduled hearings, exhibits the court lets in. In the other, the loud commentary, theories, and edits built for speed.
Stuff, but there was a point on that call where it did feel like the lawyers, or the judge rather, Judge Lyman, was basically getting a...
The first changes outcomes. The second changes moods. If you care about who wins, follow the paperwork. Watch what survives redaction, what gets excluded, and what makes it to trial. In a world where attention feels like truth, the only thing that still decides reputations is process. And when the next ruling lands, it won't shout. It'll be a few pages, a signature, and a shift you can measure.